For our next story, we are going to cover an issue that was previously covered by attorney Steve Leto on his channel. So I wanted to just show that he had covered this first because I want to give him credit for inspiring me to cover the same story that he did. And as is typical in my sort of process, once I've made the decision to cover a story, I don't want to listen to too much because I want to have my reactions be genuine. So with respect to Steve here, I did not watch his video in full because once I listened to enough of it to realize it's something I want to cover, I wanted the pleasure of being able to read it and react to it for the first time live with you guys. So when this is done, I'll go watch his video. I would encourage you to go watch his video as well because I watched enough of it to find it entertaining. So I think that you will too, but credit Steve Leto for covering this case and for inspiring me to cover it. So let's read the case that he did and have some fun with it. This is the case of United States of America versus Heather Ann Tucci-Jarraf and Randall Keith Beane. In this case, two people who were sovereign citizens decided to represent themselves in court. It didn't go well, and they insisted on representing themselves in court. And the trial judge said, "Are you sure?" many, many times, and they said, "Yes, we're sure." On appeal, they argue that the trial court should have ignored them and they should have forced them to have an attorney. So that's all kinds of irony. They think that they should be forced to have an attorney over their own objection, even though they're soft sits. So that's a thing that apparently happened. So we're going to read this decision and I suppose have one hell of a schadenfreude reaction at how their own incompetence has caught up to them in every possible way. So let's read this decision and have fun with this. Faced with financial challenges and rising unpaid bills, the individuals had two legal options: shed their debt through the humbling act of filing through bankruptcy or find a new source of assets. Randall Beane, with Heather Tucci-Jarraf's assistant, tried to find a new source of assets, an alleged trust fund of the government money in his name. But the money was not his, and along the way, the two of them defrauded the United States of $31 million. A result of their criminal trial, they each asked to represent themselves, a request the court honored after holding a hearing on the matter. The trial did not end well for either of them, and the jury rejected their array of fringe conspiracy theories. On appeal, they argued the trial court should have forced them to accept counsel in view of their unusual beliefs. Because they knowingly and intelligently made this choice, and because self-lawyering does not require an individual to subscribe to conventional legal strategies or other orthodox behavior, we affirm. For years, Randall Beane honorably worked for our country, serving as an Air Force electrical engineer. At some point, he became convinced the government was spying on the public, prompting the self-described quest into the world of conspiracy theories. His internet research led him to the straw man conspiracy theory. The government creates for each new citizen, the theory claims, a legal identification called a straw man that allows the Federal Reserve to hold in trust that citizen's inherent unlimited value. Proponents believe that by filing paperwork with the correct verbiage, they can tap into these trust funds and use them as bottomless expense accounts. Timing is everything. The theory struck a chord with Beane at a vulnerable time when he owed more money than he could pay on his vehicle, several credit cards, and 4 personal loans. Before long, he came across the work of Heather Tucci-Jarraf, which did not help matters. A former lawyer who once worked as a prosecutor and public defender, Tucci-Jarraf ran a website, posted videos, and contributed to talk shows about the strawman conspiracy theory. She also produced several faux legal documents that purported to allow individuals to access their secret trust fund accounts. Seeing Tucci-Jarraf as a visionary who could make a difference, Beane reached out to her. She committed to help Beane dispose of his old energy and to move forward and be creative as getting a new financial house in order. Oh man. Beane found an outlet for his creativity. While browsing Facebook, he came across a video by an anonymous user under the moniker of Batman villain Harvey Dent. The video purported to teach viewers how to access their secret trust fund accounts, but in truth, it taught them how to commit wire fraud by exposing a deficiency in the automated clearinghouse network that banks use to transfer funds online. Being discussed in the video with Tucci-Jarraf. She offered her own advice how to perform the technique and directed him towards potentially helpful documents. On the evening of July 3rd, Beane gave the Harvey Dent idea a try. Logging into his bank's website, he followed the video instructions and entered information it recommended. Account number, his own 9-digit social security number. Routing number, the Federal Reserves. Good. Using these credentials, Beane made a fraudulent payment in full on his personal loans, his credit card debt, and his car insurance. Elated, Beane took to Facebook to spread word that he just paid off all his debts with his trust account. Easy as this was, Beane tried again on July 5th. This time, he bought certificates of deposits with Federal Reserve funds. With Tucci-Jarraf providing moral support through video conferencing software, Beane bought CD after CD. He did not stop until his computer mouse ran out of battery charge. Then he went to bed. Beane awoke the next morning to find $28 million worth of CDs in his bank account. Before long, he increased the total to $31 million. And before long, he started cashing the CDs. With his debt cleared and plenty of cash now on hand, he bought an $86,000 truck as well as a $500,000 motorhome that had 2 bathrooms, marble floors, and a fireplace. Suspicious of his sudden fortune, one of Beane's bank accounts froze his account. Yeah, you think? It also attempted to cancel payments made on the new truck and motorhome. That is when Tucci-Jarraf re-entered the picture. She advised Beane on how to protect his new assets by placing them in the name of a trust and prepared pseudo-legal documents on his behalf. Claiming to be Beane's lawyer, she made phone calls to one of the banks and a dealership to persuade them that he rightfully owed the money that he was spending. His assurances worked, and the bank stopped canceling the payments. But just for a little while. By then, as it happened, a federal investigation had begun. I wonder why. On July the 11th, federal officers learned that Beane planned to drive off the dealership in his new motorhome. Officers rushed to the scene, arriving just as Beane started the engine. He refused to exit the vehicles, and agents had to remove them. I'm sure that was one heck of an interesting scene in real life. One of the motorhome's other occupants provided officers with Tucci-Jarraf's phone number and requested they contact her. On the phone, Tucci-Jarraf claimed that she was planning military operations. You know, that's just something the FBI loves to hear. When they get on the phone with a suspect and the suspect says, "I'm planning military operations," that's the kind of thing that just brings, special warmness to the FBI's heart, I am sure. Officers arrested her in Washington, D.C., where she had gone after contacting the Secret Service to request a meeting with the president. Okay. Wow. Beane and Tucci-Jarraf responded to their own request with a flood of frivolous motions. No way. They filed frivolous motions? Who would have thought? They demanded hearings on their own identities, the identities of the arresting officers, and the identity of the presenting judge. They asserted that the United States court cannot hold anyone except by their own consent, and the United States, a tad more plausibly, is a bankrupt corporation. Nice little shade from the Court of Appeals on the debt situation of the U.S. government. So that's a little shade there. That's a little bit interesting there. They submitted hundreds of pages of pointless uniform commercial code filings. For those of you who are waiting for the UCC to be mentioned, that's a bingo. Alleged something called the one-person public trust. They mailed the court an itemized bill seeking payment of $46 quintillion. $46 quintillion. It's a big number. I think there's more money than exists everywhere. Yeah, I think the total amount of money that totally exists might get to like 1 quintillion. Maybe. Probably not even that. No, probably not even that. That's a lot of money. I think like the total amount of money is like 2 quadrillion. There's not a quintillion dollars of assets in the world. No, not total. And by the way, when I'm saying that, like 1 quadrillion, this goes into like what counts as money and what doesn't count as money. Don't ask. I barely understand it, but there's like different categories of money. They call it like M1 money and M2 money, and like there are things that do or do not count as money depending on how you're counting. The money gets weird. I think the total amount of like all that money is like $1.7 quadrillion. So 46 quintillion is a lot, just saying. On and on it went. Concerned that such conduct might confuse a jury, the judge granted a motion to eliminate that barred the defense from raising similar arguments at trial. Yeah. Beane and Tucci-Jarraf asked to represent themselves. The judge held a hearing for each of them, complete with the standard issue inquiries and cautious about self-representation. Are you sure? Are you really sure? Are you really sure? Really? You sure? Okay. The defendant provided some unusual answers, but after an extended colloquy, the judge concluded that they had knowingly and intelligently waived their right to counsel. He granted their request. As a safeguard, he granted their request to appoint a standby counsel who can help the defendant during trial and who can take over if the judge ends the self-defense representation. The defendants did their best. They cross-examined government witnesses, introduced evidence, testified on their own behalf, and used their closing statements to justify their worldview. But their best was not good enough. The jury convinced Beane of bank and wire fraud, and both defendants of conspiracy to commit money laundering. The court sentenced Beane to 155 months and ordered him to pay $500,000 in restitution, and the court sentenced Tucci-Jarraf to 57 months. Beane and Tucci-Jarraf have had second thoughts about representing themselves. One can't imagine why. On appeal, they argue the trial judge should have saved them from themselves. No cause for reversal has been shown. The The right of counsel of the Sixth Amendment is paternalistic and libertarian components to it. On the one side, all defendants have the right of counsel in criminal cases, along with the right to have government appoint counsel if they cannot afford it, all to the end of ensuring the government does not remove someone's liberty to live freely in society without sound representation. On the other side, all defendants, whether lawyers or not, have the right to represent themselves, which amounts to the right to reject counsel and to confront the government alone. Vindication of the goals of the second option often come at the expense of the first. Look no further than to one reality of self-representation to see the tension. While the Sixth Amendment guarantees a minimum level of competence that all criminal defense lawyers must meet during a criminal case, that guarantee does not apply to self-representation. The right to waive counsel includes the right to waive effective counsel. The self-lawyer is thus free to behave as eccentrically as his client selected, and that's of no concern to the Sixth Amendment. Libertarian indeed. I just love the way that last line is shaded. It's just like the self-lawyer is free to behave as the eccentric his client selected. That's some masterclass shade. It's just like that's really good shade. All this conforms that, generally speaking, the only way out of the consequence of bad representation in a self-represented criminal trial is proof the trial court erred in letting the individual represent himself to begin with. Here, there are two questions the trial court must answer affirmatively before it allows self-lawyering. Did the defendant expressly waive the right to counsel in a knowing and intelligent manner? And did the defendant have the mental competence to quarterback his own defense? If the answer to either question is no, the judge must appoint counsel. In all other cases, the defendant has the right, the constitutional right, to go it alone. The first question to answer is whether the defendant properly surrendered his right to counsel. We have oscillated on the proper standard of review, at times giving this a fresh look, at times for plain error, and at times omitting any decision of the relevant standard. But nothing turns on that distinction here. When Beane and Tucci-Jarraf asked to represent themselves, they did all the vetting the law requires. The judge gave each proper a forata hearing, during which he asked and assessed their answers to the full suite of required questions. He also properly informed them of the severity of the charges against them and the risk of self-representation. Despite these warnings, the defendant remained unequivocal they wished to proceed alone, and their answers showed engagement with the risks and challenges of self-representation. Beane conceded his relative ignorance of the rules of evidence and rules of criminal procedure. Tucci-Jarraf recognized that, despite having gone to law school and been a lawyer at one point, she needed to refresh themselves on her as well. Both defendants also had the good sense to request a standby counsel even without prompting. Other facts supported our decision. Both defendants held demanding jobs. Beane was an electrical engineer, and Tucci-Jarraf has a job as a prosecutor and a public defender. Both had experiences representing themselves in court. Beane did so in a civil dispute, and Tucci-Jarraf in a criminal one. The alleged criminal conduct involves a complex financial activity that both defendants had plenty of mental acuity, and though not dispositive, neither defendant has any documented history of psychological problems. Beane and Tucci-Jarraf nevertheless protest the knowledge and free will requirement of the waivers by pointing to the portions of the Friday hearing which they gave odd answers to straightforward questions. When asked to be sworn in at the hearing, Beane and Tucci-Jarraf both initially responded by saying, "I am the source of all that is." Okay. Yeah, the last entity I heard say that was God when he said, "I am that I am." So, super. And Tucci-Jarraf flagged some instances in which she quibbled over the meaning of turns of phrase, the difference between true and truthful, and the meaning of pro se and pro per representation. But throughout these verbal quizzles, they represent carefully to the judge's questions and gave thorough answers. None of the answers suggested they misunderstood the questions or had cold feet about representing themselves. Beane argues the judge should have let the self-aware lawyer at the same trial as him because they were once an attorney, but Beane never thought that Tucci-Jarraf was representing him. The judge indeed assured Beane that he could not do so, and Beane acknowledged as much. Maybe it means only that he said that he foolishly adopted Tucci-Jarraf's trial strategy, but that fact alone would not justify severance, as it carried no risk of compromising one of Beane's specific trial rights. And even if Tucci-Jarraf had advanced a defense directly antagonistic to Beane, this would present an issue only if the defense had the potential to mislead or confuse the jury. No such issue arose, and all the events Beane never asked to sever. Both defendants claim that they should have been allowed to represent themselves without a competency hearing. Mental incompetence is a high bar to clear. To qualify, defendants must lack their wherewithal to understand the nature and consequences of the proceeding against them, or to assist properly in defending themselves. Because they require proof of deep breakdown in cognition, even patients with severe mental illnesses often fall short of the threshold. Trial judges must hold a competency hearing in the context of forata claim only when they find a reasonable cause for concern. This demands a difficult, fact-intensive judgment call of the trial court, one that generates a heap of deference. So just how much deference is up for debate? We never decide whether to have used these for abuse of discretion or plain error. No matter how you slice it, however, neither defendant clears one of these lofty bars. Beane and Tucci-Jarraf never gave the judge adequate cause to fear their mental competence. Really? Seems like they might have been sub-cause, but okay. At all stages of the proceedings, they stuck to the prescribed rules, interacted courteously with the court and prosecution, and collaborated effectively with their appointed standby counsel. The government, notably, had to raise only a few objections to trial, all relatively minor, and the rare occasion where a judge provided the instruction, they heeded it without protest. Nor did Beane and Tucci-Jarraf defense suggest they lacked the capacity to compete with the prosecution. When they gave plenty of airtime to implausible conspiracy theories, they succeeded in other aspects. During cross-examination, they asked logical questions aimed at exposing gaps in a witness's knowledge and inconsistencies of the prosecution's narrative. During testimony, they successfully introduced helpful biographical details, information about their upbringings, their motivations, and history of government service. And during closing arguments, they clearly explained their belief system and articulated what led them to do why they did. Sure, experienced counsel would have done a better job, but that really doesn't show the defendants were too incompetent to represent themselves. Else, lay people could never represent. Tucci-Jarraf separately challenges the conclusion on the grounds that she should not have been permitted to stand trial, with or without a lawyer. But we tend to treat both claims, this one and the one adjudicated, as identical. Although a trial judge may from time to time impose counsel on a mentally compromised defendant just competent enough to share trial, they aren't required to paternalize defendants in this way. So just by way of legal aside, there is a technical difference between competence to stand trial and competence to act in your own capacity. There is a slightly different standard. So it's theoretically possible to be competent enough to stand trial, but incompetent enough to not act as your own lawyer, but it's a pretty thin slice and it's not relevant here. That leaves the main challenge to both defendants raising their self-representation, that their idiosyncratic actions and unconventional beliefs establish proof above themselves of unsound mind. But if committing murder does not automatically generate a competency hearing or a competency finding, we're hard-pressed to understand why fantastical financial crimes would automatically do so. The hard reality is that libertarian values of the Sixth Amendment allow individuals charged with crimes to act in unorthodox ways, even if it compromises other values of the Sixth Amendment, which makes sense because they're your rights. They belong to you. So if you're waiving them, well, who are we to object, I guess? Just as the First Amendment does not require an individual to accept the most defense and battle-tested political views, so the Sixth Amendment does not require adherence to unorthodox or orthodox criminal defense strategies. In case after case, we've rejected this argument for comparable reasons. For its part, the Supreme Court has never suggested that eccentric worldview standing alone establish a mental incompetence. The hard fact is that intelligent people, even very intelligent people, can believe baffling things. The same brain that allows them to be very intelligent can, with combined with financial and other stress, trigger all kinds of irrational behavior. Count Beane and Tucci-Jarraf. Oh, I was wondering why I said Count Beane. I'm like, is that a title? No, it's the word to count. Okay, I was worried when I said Count Beane. I'm like, is that a title? Jesus. All right. Count Beane and Tucci-Jarraf among those number. Count also the thousands of other straw man conspiracy theories proponents nationwide. These individuals, of course, are misguided, sometimes dangerously so, but that does not mean they inherit a private mental word wholly divorced from reality, and certainly does not shield them from the consequences of their action. Membership in our democracy, is to say, does not come with an unlimited trust fund, at least a financial one, but it does come with a view of dignity of the individuals made weighty for decisions for themselves. That is why they may reject life-saving health care, consent to incriminating searches, conduct their own criminal defense as they see fit, and perhaps most harmfully, but rational all the same, to confess to convictions of crimes. Exerting these rights sometimes costs individuals more than they could ever stand to gain, but the Constitution lets American citizens learn the hard way. Tucci-Jarraf separately contends the 2-level enhancement she received for her special skills as a lawyer to significantly facilitate the crime or concealment of a criminal offense. We see nothing improper about the enhancement, even if the skill did not prove effective at trial. Outstanding shade. That's some good shade, man. Oof. Yeah, you're lawyer enough for the sentencing enhancement, but not lawyer enough to be able to help yourself. That's some excellent shade. Good job. The sentencing guidelines list legal training as a special skill, and the judge did not err in concluding that Tucci-Jarraf used that training to assist Beane in the commission and concealment of the fraud. Commission. Tucci-Jarraf advised Beane on how to perform the scheme. Concealment. Tucci-Jarraf's legal training helped her prepare documents that increased her credibility with banks, which allowed her to delay discovery of the fraud. Not quite so, counters Tucci-Jarraf. While she has experience as a practicing lawyer, the documents she prepared and the arguments she made were devoid of real law. You don't say. We agree the arguments were frivolous, but that reality does not get her off the hook. Tucci-Jarraf's goal was not to fool a veteran attorney, it was to use legal jargon and official-looking documents to disorient bank and dealership employees, and she succeeded for a while. At trial, one bank testified that Tucci-Jarraf's identification of Beane's lawyer definitely played a role in the bank's decision not to rescind the payment properly. That sounds a lot like United States versus Congrove, when we upheld the special skill enhancement because the lawyer held himself out as an entity's counsel, giving those who dealt with him the mistaken impression that the claims would be handled properly. So too for Tucci-Jarraf. Sure, Tucci-Jarraf's effort to protect Beane failed in the end, but that does not prevent the special skill enhancement from applying. Even ultimately unsuccessful conduct can preclude further inquiry. When it seems that crimes like conspiracy require only the defendant intended to employ her special skill in furtherance of the crime. Successful or not, Tucci-Jarraf harbored just such an offense. We affirm. Well, I'm super happy we spent the time covering that story, guys. That was all kinds of special. And it just shows the kinds of special that exist. And wow, it's amazing. It's sub levels that it's that special. It's like the things that go through people's minds and the soft sits. And we should force counsel on them. But as the court rightly points out, the Constitution is a series of negative rights. They belong to you and the government can't take them away from you. But if you want to give them up, who are we to disagree? Everyone is free. And you're free to do stupid things, unfortunately. And so, well, enjoy going to jail, I suppose, for both your financial crimes and your decision not to have a lawyer. Although I seriously doubt getting a lawyer would have helped very much because it seems like there was some pretty solid evidence. So I doubt it would have made a difference either way. But, soft sit's going to soft sit, I guess, is the heroic conclusion from that story.